Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, throughout most of 2022, and I now know going into 23, we have been spending a ton of time following litigation, not only here in Washington State and Oregon, but all around the country, fighting against AR bans, fighting against magazine bans, fighting against restrictions on unfinished frames and receivers, pre-purchasing licensing requirements, ridiculous concealed carry requirements. The list goes on. And many of you have been geeking out with us as we follow this litigation throughout its trials and tribulations. And as you know, there is a lot of terminology that gets kicked around by lawyers because we like to use fancy terms because it makes us appear smarter than we really are. One of the things that we try to do here at Washington Gun Law is just get everyone on the same page. Let's talk in simple English. Let's break it all down so that we can understand it, and you all can decide what does that really mean to you. So we're going to talk about a legal term that I think you probably hear a lot, and let's break it down and figure out what it really means to us and what does it mean in all of this gun control litigation. So today, let's spend a few minutes, get you all up to speed on what exactly is legal standing and what does it mean in gun control litigation? Okay, so this is another video in this series of videos that we are doing. It's high geek out material. We are going deep into the woods about certain things, but I think that for those of you who really want to understand what is going on with your Second Amendment rights and how they are being played around like a little pawn in a game of chess, to understand what lawyers are doing, you should understand some of the terminology and what these things mean so that you understand what it means to the effect it has on the litigation. One of the words that you hear all the time is standing. And the party who is routinely screaming, "There's no standing," is not the plaintiffs. It's not the people suing to overturn unconstitutional gun laws. No. It is always your attorney generals, your U.S. attorneys. They are the ones that are screaming that, hey, the plaintiffs don't have standing. What the hell does that mean? Well, the term standing comes from the Latin phrase locus standi, and for those of you who geek out with me that went to law school, you know we all know a bunch of absolutely worthless Latin that we used probably in law school and when we were sitting in a bar in law school, and beyond that, we've never used that crap ever since. Locus standi, or what we like to call standing, is essentially really simple as, hey, do you have a dog in this fight? You see, you don't get to sue the government for unconstitutional law just because you don't like it, just because you think it's bad, just because you think it's unconstitutional. No, you actually do not get to sue the government for that reason. They could write the most unconstitutional, blatantly unconstitutional law on the planet, and God knows we have some states in this country that are working feverishly to do exactly that. However, unless the person suing can say, hey, I have actual injury here because of this law, they do not have standing. They do not have a dog in the fight. They do not have a leg to stand on as to why they should be a party to this argument. Now, we see in a lot of these extremely blue gun-grabbing states that as soon as these archaic Orwellian type gun control legislation pieces are enacted into law, a lawsuit comes immediately, and immediately the state's attorney, or if it's federal legislation, the U.S. attorney will immediately scream, hey, there's no standing here. And the argument they make is twofold, and I want you to understand this because it really begins to show the disingenuous nature of this gun control legislation. The first argument is hey, this person can't actually show injury. That is, they haven't been prosecuted under this law. They haven't shown how it affects them. The second thing, and you see this more on the state level, this argument routinely comes from California, by the way, which is, hey, listen, they're never going to really be able to prove standing because it's highly unlikely that we're actually going to really enforce the law. Now, I want you to think about that argument because Rob Bonta has used that argument on multiple occasions. Bob Ferguson has used that argument on multiple occasions in Washington State, by the way, which is, hey, listen, there's no evidence to suggest that we're even going to enforce the law as strictly as it's written. Well, these laws are written, at least I'm told, to save lives. If they're written to save lives, why then do we not enforce them? Or are they not written to save lives? Is gun control shockingly not about the guns, but rather about the control? Now, on the state side of things, standing is determined into, can you actually show injury in fact? That is actual injury. And when we take a look, for example, with the magazine ban litigation that's been going on both in Sullivan v. Ferguson and Brumback v. Ferguson, what the Attorney General's office has consistently been crying is that nobody here has standing. Nobody has any actual injury. The gun stores can still sell magazines. They just can't sell high-capacity magazines. People can still possess the high-capacity magazines that they own, and they can still carry them, so therefore there's no actual injury there. And so the state has routinely been screaming that none of the plaintiffs in Sullivan v. Ferguson or Brumback v. Ferguson have any standing to even bring this suit. However, let us now remember that the Attorney General's office has decided to sue not one, but 2 gun stores for selling magazines that this law now prohibits under the Consumer Protection Act. So that, undoubtedly, if you are one of those 2 gun stores, is in fact injury in fact. On the federal level, things get a little bit grayer, but the test is relatively the same. You have to show that there is injury in fact to the plaintiff, and you also have to show that there is redress, that is, there is a remedy available by the action that the plaintiff has taken. In fact, there is a 3-part test developed in a case called Lujan versus Defenders of Wildlife, and the 3-part test on the federal level to determine if there is standing is as follows. 1, the plaintiff must have suffered an injury in fact, meaning that the injury is of legally protected interest, which is A, concrete and particularized, and B, actual or imminent. 2, there must be a causal connection between the injury and the conduct brought before the court. And 3, it must be likely, rather than speculative, that a favorable decision by the court will redress the injury. So the bottom line, in a nutshell, if we're going to wrap this all up and put it in a nutshell for our English-speaking friends, is what standing means is, hey, have you been actually and adversely affected by this law? Can you prove that? Essentially, prove to us that you have a dog in the fight. If you do, you have standing. That means you can bring the suit. If you do not, it means, hey, you're picking the fight with the wrong people. You're barking up the wrong tree, whatever other metaphor you want to use. Listen, you may have more questions about this or any of the other things that we've talked about in our deep geek legal sessions. If you do, you know the drill. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation, and that would apply to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.